You can't convict me.
Right, welcome back to What's Trending. Nnamdi Kanu, embattled leader of the Indigenous People of Biafra, has on Friday blown hot in court after the latter fixed a date to deliver judgment on Kanu's terrorism trial. The Federal High Court in Abuja has scheduled November 20, 2025 for the delivery of judgment in the terrorism trial of Kanu. The decision was made by Justice James Omotocho following Kanu's failure to open his defense within the 6 days allocated by the court. The judge ruled that Kanu, having not utilized the opportunity to present a defense, has effectively waived his right to a fair hearing under the Constitution. Nnamdi Kanu has been in detention since 2021, facing 7 terrorism-related charges, primarily linked to his separatist campaign for the independence of Nigeria's southeast region as Biafra. While Kanu has pleaded not guilty, he maintains that the charges are invalid, arguing that they are based on repealed terrorism laws. He has also challenged the court's jurisdiction and the legal basis of the prosecution. The trial commenced several years ago, with the prosecution presenting 5 witnesses before closing his case. Throughout the proceedings, Kanu has frequently dismissed the charges and resisted participating in the defense phase. His decision to represent himself followed his disengagement from his lawyers. The court has granted multiple adjournments to allow him opportunities to respond, but Kanu consistently refused to engage fully with the legal process until recently. In the latest development, Kanu began filing his defense documents directly in court, complying partially with the court's instructions in a move overseen by Justice Omotocho. The judge facilitated the filings by temporarily relocating the court registry to the courtroom to accommodate Kanu's constraints. This case represents a critical moment in Nigeria's ongoing struggle with separatist movements and the legal battle surrounding them. The November 20th judgment date marks a significant milestone that will determine the immediate legal fate of one of Nigeria's most prominent and controversial separatist leaders. For more insight into this story, do not hesitate to hit the like button, make your comments, share my videos, and subscribe to DDM TV. I'm Tochukwu Raphael. See you next time. Thanks for watching.
Good.
Supreme Court said do something, you didn't do it. And you're here sitting conviction. And you wonder why God cost you this. Useless black. You don't know what justice means? You have no idea what justice means. You don't know what justice means. Useless black African people. You don't even know what justice. Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me written law. I want to know
Don't talk to me now. Why are you pushing me?
show written law.
Are you okay?
Don't go close. Don't try that rubbish. Don't try it. Don't try it.
Let me go ahead and say what.
Don't try that rubbish.
Say what they say.
Don't try that rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. Supreme Court judgment you don't respect. Then why are we in the court of law? Why are we in the court of law, I ask? Nonsense. You think Britain can ask you to jail me and you will jail me? You are dreaming. You are dreaming. I'm telling you that you are dreaming. Nonsense.
Good morning.
Yes, I know you attended the proceedings today.
Yes, I did.
For Nigerians to know.
Yeah.
Just a summary of what happened.
Well, what happened in court today, for me, continues to be travesty of justice. I've always said it that in Nigeria there appear to be two sets of rules, one for the Igbo man and another for the other Nigerians. This is exactly what I saw in court today. First of all, my name is Honorable Obi Agocha. I represent the great people of Iguano, Umuahia North and Umuahia South Federal Constituency. I am the primary representative for Mazi Nnamdi Kanu. So I'm going to speak to you as a layman. I'm not a lawyer.
You understand that you are no longer in Kanu's legal?
No.
So,
We remain as consultants to him
okay.
and as his brothers and braves in council.
Okay, based on today's proceedings, what did you observe and what is the way forward?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Mazi Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empower the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings today.
The procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that.
It's good for us to put the record straight. Mazi Nnamdi Kanu is not saying that he will not enter defense. Mazi Nnamdi Kanu said, under what law are you charging me? Going by the constitution, there is no charge against him. That tell me the law, that the court should tell him the law upon which he's been tried. Now, my lord is on saying that whatever thing that you have to say should be ruled at the final written address, and it should be upon a conviction to know whether you are supposed to be convicted or not. And Nnamdi Kanu said no. There are thresholds, there are hurdles upon which you need to cross for you to reach at that particular issue. And one fundamental issue there is that my law said we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria, and they want somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Nnamdi Kanu filed, Nnamdi Kanu said Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Nnamdi Kanu made reference of the motion in the court file. Yes. And under the Evidence Act, Nnamdi Kanu is saying that under the law, court is obliged, is under obligation to take judicial notice of every document in your file. Yes. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. Yes. That court is on its own supposed to take to raise this issue. Yeah. Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Nnamdi Kanu filed the motion, and I think that motion, Nnamdi Kanu said that motion should be heard, and all this issue I raised should be trashed for me to go into trial. So, and into defense. So my law, Nnamdi Kanu maintain his position on that. So my law said that he has joined to tomorrow for him to enter defense. Just like we said, we are no longer into the matter, but we are still he's still consulting us. I don't say so. On handling his matter in court, he felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice, just to get the record straight, so that people will not say that Nnamdi Kanu refused to enter defense. No, there is no such issue. Nnamdi Kanu said, address me on this issue. Okay. That is the position.
The honorable member here will...
My name is Right Honorable Obi Akocha. I represent the great people of Ikuano, Umuahia North and Umuahia South Federal Constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter a nolle prosequi, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
Okay. My colleague here would like to...
Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code.